it. But yeah, you can go ahead and record.
Yeah, so we will be recording this meeting. For everyone's information, we're going to go over general legal information. We cannot provide legal advice during this session. If anyone needs legal advice or assistance in preparing a will, we would be glad to talk to them individually and to connect with them and assist them with their individual matter. Thank you, Raina.
Thank you, Ring. Oh, I want to share my screen. Can you give me permission to do so? I'm sorry, I prepared a PowerPoint slide as well to go over the information, just to give you a visual of what wills are and why they're important. Thank you. Can you see my screen? No, you can't. You can see my screen now, right? Yes, you can. Perfect. Wills are important. They give us, wills are a powerful tool. They're a part of estate planning, which is important. It gives us the tools necessary to plan for our future, plan for the property that we own now, plan for generations, and help. It's a tool to help us build generational wealth. And I started off with a quote that says, from Rosa Parks, that says, "I have learned over the years that when one's mind is made up, this diminishes fear. Knowing what must be done does away with fear." And I thought this was huge because when we are writing our wills and preparing for our demise, this is kind of scary and overwhelming. But once we go through the process, it makes, it helps us be able to move forward and do these things. What is a will? A will is a legal document that dictates who gets your assets after your death. In Ohio, a written will must be signed in front of two people who have no interest in the will. So if you're writing a will, for example, it can't be the two people you're signing the will in front of cannot be beneficiaries of the will, right? And please stop and let us know if you have any questions. I forgot to say that earlier and at the beginning. And the next bullet point is super important. Though you can prepare your own will, it's wise to have your will prepared by an attorney so that you are empowered to make the best decisions for you, your family, and your estate. Wills are important because it's a document that helps dictates who takes care of your minor children or any people that do need any specific type of care after you're gone. And one of the reasons why I think that wills are important is because I think I've seen time and time again, people, once someone dies, folks are scrambling. They don't know what's going on. They don't know what to do with their loved ones' houses, debts, and otherwise. And failure to have a will often leaves important decisions to be made by the government, to be made by courts. The uncertainty of what happens after someone passes away leaves us to experience avoidable pain, confusion, and strife. And I think we've all experienced that in one way or another when we've dealt with a loved one that passed away without having a will. And who can make a will, right? Hello, Miss Alicia. In the blah, blah, blah. Hello, Miss Alicia. Who can make a will, right? Any person that is 18 years and older, of sound mind and not under undue influence may make a will in the state of Ohio. And if you're, I'm sorry.
I'm sorry for being late. That's all I'm saying.
Oh, welcome. I know you're doing great work.
Thank you.
You're welcome. And if you are married, each spouse must have their own wills. Okay, you can't just have one will for to cover the whole marriage. That's a mistake that's often made. And why should you have a will, right? You have the power to determine where your assets go, who gets what and how much. You have the power to determine who manages your estate, and you can identify who should care for your loved ones if necessary. You can ensure that your heir has access to the money and property faster and more efficiently. And it avoids that limbo stage that many families experience. You can stop someone from getting your assets, right? This is especially important if you don't like them or if they owe you money. I think that's huge too. It might not be, well, it might, oftentimes people get money and property after a loved one passes away, that the person that passed away doesn't necessarily want them to have the money, but that's what the law dictates. So you have the power to change that and to determine who gets what you have. If you're donating the money and property, you can save in estate taxes, and you have the power to determine what happens to your physical remains. If you want your body to be donated to science, if you want to be buried somewhere in particular, or if you would like to be cremated, those are certain things you can have drawn out in your will. And this is completely different than a living will, right? I really dislike that will and living will are so close in terminology. So I thought I'd put that in here just to be completely and upfront, and so everyone could take note. A living will is the document that gives that dictates how you'd like to receive your end of life medical care. This is definitely huge. And a PowerPoint will be made available to you, but I clicked a link so you could have all the information about how to draft your living will, or go over drafting a living will with your attorney. And a will lasts forever. A property executed will is valid as long as it's not revoked, right? A will is revoked when a new will is executed, and it's also revoked if the will is destroyed with the intent to revoke the will. Not an accidental destroyed, like the will was accidentally destroyed. If the person says, hey, I no longer want this to be my will ever again, that would be something intentional. It has to be wholly intentional. And a will can be modified though by a document called a codicil. And it is strongly recommended to have your will reviewed if you get married, divorced, remarried, have a child, have another child, etc. Welcome, Michael. And I'd like to end by saying you can do this. Please reach out to a lawyer to assist you in creating a will. I've attached a checklist of documents to bring to the meeting with your attorney and things to take into consideration. The link below contains a long list of probate court rules. And please remember that you are powerful and you're capable of taking the future into your own hands. Yes, and that's all. And I guess I can change the, show you all the document, which I can have emailed to everyone, the checklist document, because I think that's very important as well. For everyone to have as a tool.
So while Raina does that, I wanted to share some fun facts about Ohio law, which it's true that you can disinherit someone. There is one person that Ohio law says you can't choose to give them zero money, and that person is your spouse. So Ohio law provides some protection for a spouse who is disinherited in will. And not gonna get into the details of that, but there's a certain amount of money that a spouse can still get from the inheritance amount, even if they are disinherited. So we wanted to give you that fun fact so that you can keep it on your mind.
Absolutely. Thank you, Reem. And as far as the document, the checklist goes, it can be kind of overwhelming because when you do meet with your attorney, when we first talked about having this event, we were going to just say, hey, everyone, let's come draft a will, without even giving people the tools necessary to draft a will and like, hey, this is what you bring. So this is a will preparation checklist. So when you do meet with your attorney to draft the will, you should bring all of your certificates, birth certificates, death certificates, marriage and divorce certificates, financial documents, deeds, mortgages, bank accounts, debts, list of advisors that you already have, any bankers, lawyers, accountants, investment dealers, and insurance agents, And make sure a designated member and or executor knows where to find your information. If you're keeping your will in your drawer next to your bedside, that person needs to know where you're keeping that document, where you keep other important documents. An executor is a person you name to carry out your wishes after you pass away, and they must agree to act as your executor. Welcome. And the next bullet point is, do you want to leave any bequests? Bequests are specific items of personal property, such as jewelry, cars, heirlooms, clothing, or sum of money you want to leave a specific person. Please list them, right? Don't leave them to be vague. And remember that just because an item doesn't have a huge financial value, that doesn't mean it doesn't have a great sentimental value, historical value, etc. So please, if you can think of anything that is important to someone or important to a group of people, please make that very clear. And who do you wish to have the remainder of your estate? Do you want it to be left? The remainder of your estate is everything that's not listed specifically, like the leftovers, right? So who do you want? Do you want that to be left to a spouse, your children? And if they're minor children, do you want them to receive it now or at a future time? Do you want the remainder to be left to relatives, charities, an institution, or go directly through a trust? Or do you want it to be through a trust? And like we talked about, how do you want to be memorialized or laid to rest? And if your children have died, if you've lost a child, do you want your child to receive the share, or do you want the share to go to their children? Or would you like the children of that child to receive that share, or would you like the share to go to your other children? And like we talked about before, who will you name the guardian to be guardian of your dependent children or disabled adult children? The guardian, like the executor, must agree to act. And if this is your second marriage, which Reem was talking about earlier, and you both have children from previous marriages, you may want to consider the available options. You must discuss the various options with your spouse and agree upon your plans, okay? The remainder of your estate can go to your current spouse, your children, your current spouse for the use while alive, and then after your spouse dies, to your children, or your children and the children of your spouse. So those are things you can keep in mind as you're preparing to meet with your attorney and prepare your will.
Well, look at that. When I did those sessions, there weren't as many people as there are today for you, Lena. So that's awesome. I'm glad to know that people are really invested and interested in protecting their wealth and protecting the wealth of the community by writing wills. So the checklist that Reina prepared is something that we can send to everyone. You can go over it, prepare those documents, and then come back to us and let us know that you are ready to work on writing a will. Writing a will is not that difficult. It's not that complicated. We know it seems daunting, but once you sit down with us, you will hopefully not feel daunted by it anymore.
Yes. Does anyone have any questions?
Yes, I have one.
Yes.
At what point does probate come involved? Does a will allow you to bypass probate?
So the purpose of writing a will is to avoid getting into probate court. That is correct. If you don't have a will, you have to go through probate court. If you have a will and you have an executor for that will, everything should be fine unless someone challenges the will, at which point they would take you to probate court. Or sorry, not take you, take whoever is being challenged.
Thank you.
You're welcome.
Will versus trust. What's the difference? Did I miss that?
You did not miss that. I don't believe we covered that. A trust is something that you put your, a trust is something that people can put their belongings, their finances, their homes in, and they decide the terms of that trust. When something is placed in a trust, it leaves the ownership of the person. It then sits in this fictional entity that's called a trust. It's almost like there's a person, but it's a trust that holds ownership over those, again, bank accounts, homes, land, whatever it is. There are different kinds of trusts. We're not going into the details of that here today. There are revocable trusts and there are irrevocable trusts, and there's trusts where you put funds for someone's education and so on and so forth. A will is something that leaves everything as it is until such point as the drafter of the will has passed away. So as long as they're alive, the ownership of those belongings does not change. Whereas in the trust situation, there is a change during the lifetime of the owner. And each have their benefits. Even if someone has a trust, they should still have a will. But not everyone needs a trust.
Right.
So the trust, you can talk as yourself, basically, with what exactly you want to take place, even once you're gone.
In both situations, you can decide what you want to happen. Okay, the difference is the trust, you decide what happens starting now.
Right.
With the will, you decide what happens starting after your death. Does that make sense?
Yes.
Okay, awesome. Happy to explain it further. Sometimes, I say things that aren't clear and I'm happy to rephrase them if you need me to.
Does anyone else have any questions?
So just to elaborate, since we have some more time, trusts are sometimes really beneficial in handling the taxable income rates for people. So that, if someone had a lot of wealth and a lot of rental properties, they could move those into a trust. And then the trustee who oversees the distribution of what's in the trust can distribute that to that person's kids or spouse so that they're not getting the money and then giving it to their kids if that's what they were going to do anyways. So again, it's impacting those relationships during the person's life. A will cannot do that. The only way that a will works is it begins working after the passage, the death of the person. Other questions? No questions from you, OC?
Green, this is Alicia. I'm wondering if there's a need now that we understand or have somewhat of an understanding of what the living will, if we need to do something next on a trust and what we can put into a trust, how that can, be beneficial. Is that something that we could possibly do?
For sure.
Sure.
Wonderful.
Absolutely. We'll talk about those, we'll talk to you about the details and get it planned. Sounds like
Wonderful, Raina. I think that would be great. And even possibly having a template to allow folks to be able to just kind of understand the process.
We can provide templates for how to set up a trust.
Wonderful. Thank you.
You're
Our attorney's
welcome.
right. I just wanted to say that.
Well, if there's nothing else, we're gonna end the session.
We're gonna stop recording.
Okay.
And we want to make sure everyone understands that this is recorded. It will be available via